Hello, my name is Professor Geoff Gilbert and I'm about to make a presentation on the subject of exclusion for the purposes of refugee status determination. This presentation proceeds on the basis that those watching it are already familiar with inclusion under Article 1A of the 1951 Convention and with complementary protection under international human rights law. However, exclusion also requires an understanding at some times of international law of armed conflict, international humanitarian law that is, and international criminal law. There is no assumption of knowledge with respect to either of those subjects, and what you need will be explained in the remainder of this presentation. Equally, there's absolutely no way that I can remember all of the relevant materials set out in treaties or in case law that I'm going to need to refer to during this presentation. And at times you'll actually see me reading this because there's no point at all in trying to learn the materials by rote. To that end, at the end of the presentation there'll be a reading list that you can take away so that you can go more thoroughly into the subject, because no matter how long I spoke for, it would be pointless to try and explain everything in this video to do with exclusion, complementary protection and all the other branches of international law that are pertinent to this particular area of study. Thus, the next thing that probably I should set out are the materials that you should have to hand whilst watching the video. They are Article 1F of the 1951 Convention, Article 33(2) of the 1951 Convention, Article 1, subparagraphs 4 and 5 of the 1969 Convention governing specific aspects of refugee problems in Africa, and paragraph 7 of the Statute of UNHCR dating from 1950. All those materials have bearing on how one interprets exclusion. So let's start with Article 1F. This is an incredibly brief overview because the details are going to follow in the rest of the presentation. Article 1FA, Article 1FB and Article 1FC all provide individual grounds for excluding someone from the protection of the 1951 Convention. If Article 1F applies, the person falls outside the convention, and it doesn't matter whether it's 1FA, 1FB or 1FC. Equally, from the travaux préparatoire to the 1951 Convention, it's clear that there were two purposes to be served by Article 1F. First, that only those who were worthy of refugee protection should be protected. One must remember that this is immediately in the aftermath of World War II, when there were a lot of people seeking protection, some of whom had committed grave crimes during that conflict. The other reason, and this is one that is not given as much prominence as the worthiness of the applicant, is non-impunity. At the time, in the early 1950s, prosecution for crimes was based primarily on territoriality or nationality of the accused. Not so today, where there are much wider grounds for asserting jurisdiction to prosecute. But if one thinks about it, someone who is applying for refugee status would by definition almost have committed the crime in a different territory and not be a national of the state. So there was a fear that refugee status might lead to impunity. Throughout this presentation, 1F will be our major focus, but it has to be remembered this is a limitation on a humanitarian provision, refugee status as set out in Article 1A, and as such it should be interpreted restrictively. Article 1F must be read carefully and only used to exclude where the person clearly falls within its provisions. One way in which Article 1F is applied in a restrictive fashion is through the allocation of the burden and standard of proof. The burden of proof should be on the state to show that there are serious reasons for considering that the fugitive falls within the provisions of that article. The standard of proof, serious reasons, is higher than a mere suspicion, more demanding than reasonable grounds for suspecting. If that's 1F, turning to Article 1 of the 1969 African Convention, that would appear on its face to be broader than Article 1F. For instance, paragraph 1.5c refers to activities that are contrary to the purpose and principles of the then Organisation of African Unity. UNHCR has argued persuasively that since this is a restrictive provision on the humanitarian guarantee, it should be interpreted in a manner that is narrow, and as such Article 1.5c of the 1969 Convention should be read in line with Article 1FC of the 1951 Convention, which, as we will come to later on, refers to acts contrary to the purposes and principles of the United Nations. So it's only those purposes and principles of the then OAU that are in line with the principles and purposes of the UN that should lead to exclusion. Turning to Article 33.2 of the 1951 Convention, this is slightly different. It's not properly an exclusion clause, but since it can lead to the removal of non-refoulement guarantees, I'm going to include it in this video. Article 33.2 doesn't stop the person being a refugee like Article 1F does. Article 33.2 simply says that the benefit of Article 33.1, the guarantee of non-refoulement, may not, however, be claimed by a refugee whom there are reasonable grounds for regarding as a danger to the security of the country in which he is, or who, having been convicted by a final judgment of a particularly serious crime, constitutes a danger to the community of that country. This is different, and I will deal with Article 33.2 in some detail below. But the point I want to get across at present is Article 1F cannot be seen in isolation. It has to be seen with Article 33.2. The two interact. The final provision to which I want to refer is paragraph 7d of the 1950 statute. The 1950 statute holds that the High Commissioner's competence shall not extend to a person in respect of whom there are serious reasons for considering that he has committed a crime covered by the provisions of treaties of extradition, or a crime mentioned in Article 6 of the London Charter of the International Military Tribunal, or by the provisions of Article 14, paragraph 2 of the Universal Declaration of Human Rights. This is completely different language to Article 1F. It can help us understand Article 1F, but even UNHCR, when it carries out status determination, defers to Article 1F as the subsequent treaty provision. There may be questions about that approach. Our UNHCR's primary mandate is to provide international protection to refugees, and if a reading of paragraph 7d would lead to a person not being excluded when UNHCR is carrying out RSD under its statute, logically one would assume that it should apply 7d as opposed to 1F. That being said, when UNHCR is carrying out status determination in those circumstances, it's usually with the objective that the person will be resettled, in a third state, and that third state will, of course, want to see that the person is not excluded under Article 1F of the 1951 Convention. Therefore, to that extent, it is probably appropriate for UNHCR to use Article 1F's definition of exclusion, not paragraph 7d. Turning to complementary protection under international human rights law, the starting point has to be Article 3 of the UN Convention Against Torture of 1984, which reads, "No state shall expel, return, refugee, or extradite a person to another state where there are substantial grounds for believing that he will be in danger of being subjected to torture as defined in Article 1 of that convention." At the universal level, the next convention to look at would be the International Covenant on Civil and Political Rights, in particular Articles 6 and 7, dealing with right to life and freedom from torture, cruel, inhuman or degrading treatment or punishment. The leading authority there would be Judge in Canada. At the European level, there has been a plethora of jurisprudence since 1989 on return to face torture under Article 3. Article 3 prohibits torture, inhuman or degrading treatment or punishment, and in 1989, in the case of Söring, the European Court of Human Rights held that required states party to the European Convention on Human Rights not to send someone back to another state where there would be a real risk of a violation of Article 3. Cases such as Jahal in the United Kingdom, Sardi in Italy, NA in the United Kingdom, they form the basis of how one might use complementary protection in an exclusion situation. Before leaving these introductory areas, there are two topics that still need to be considered. The first is the inclusion-exclusion debate. Should one carry out inclusion before exclusion? UNHCR clearly argue in favour of that. I argue in favour of that. To my mind, there is no point carrying out an analysis of whether someone should be excluded until you've worked out whether they should be included within Article 1A of the 1951 Convention, whether they have a well-founded fear of persecution for one of the 5 grounds and are unable or unwilling to avail themselves of the protection of their country of nationality. That being said, Canada and the Netherlands do carry out exclusion before inclusion. One other matter, confidentiality. When investigating exclusion, one is possibly going to have to find out information about what the applicant for refugee status did in their country of nationality before leaving. This might give rise to an awareness within the country of nationality that this person is now to be found in this other state, the state that should be providing protection. And if it becomes clear that they've left, that they're applying for refugee status, in the case of some states, that might put them at risk if they weren't at risk before, but equally it might put any members of their family or associates back in their country of nationality at risk. Therefore, it is important at all times during the exclusion process for the state investigating whether the applicant needs to be excluded to maintain confidentiality, to protect that person against any threat that would arise simply from having made an application for refugee status outside their country of nationality. On that basis, if we've covered the background material, we'll turn to Article 1F in some detail.